Hello, everyone. Welcome to the final installation of the University of the West Indies St. Augustine Campus Faculty of Law Research Skills Series. So today I'm very excited to welcome two of my good friends. First of all, we'll have Professor Yvette Liebesman talking about copyright and publications. So she's going to be giving us the US perspective. Very important to understand the US perspective because many of us in the region look to focus both on the Caribbean, the UK, and the US. And the US having slightly different approaches than the UK is not something we are always aware of. We'll also have Dr. Adrienne Yong, who's going to be speaking to us about research impact. Anyone in academia knows that this is a huge word these days, a huge buzz phrase, but what does it actually mean? She's going to be talking to us about that. So I'm going to hand it over to Yvette. Each speaker, as you know, for those of you who have been here before, will have half an hour, and they will let you know whether they will have questions throughout or whether they prefer those questions to be asked at the end.
Hi there. Thank you very much, Emma. I'm Professor Yvette Joy Liebesman at St. Louis University School of Law. I'm really happy to be speaking with you. I'm also happy to take questions during it. I think the best way to do that is I have the list of participants to the side. I think maybe if you just like raise your hand or something, I should be able to see that and I can call on you. So I'm here to talk to you about publishing contracts and how to retain or regain your copyright rights in your works of authorship, focusing, like Emma said, on US law, since many of the publications that you may be wanting to have your work shared in are going to be US publications. We're also a member of the Berne Convention, so other Berne Convention countries are also going to be looking to the US in terms of enforcing their rights. So it's I prepared this in consultation with the Authors Alliance, and I'll explain what they are and their, how they're what their focus is in a minute. So it is important for us to understand the rights we have in our works, and this is going to affect how our works are disseminated to the public, and we want our scholarship to be read by many people as possible. There's basically two kinds of writers: the ones who want it read but really want to make money off their writing, and then there are those who want it read by as many people as possible, and the financial rewards just aren't there, or like, I don't make any money on my law review articles, but I want them read and I want them disseminated as much as possible. So we want to make sure that publishers don't inhibit our ability to disseminate material that they don't want to do anymore, or if we want to make new or revised editions of our books. So like I said, today's presentation is prepared in conjunction with the Authors Alliance, and it's going to be covering some key topics. We're going to be doing the US IP basics. I'm going to be focusing then on copyright and what open access is, reversion, termination, and publication contracts. So when we think of property, we think of objects, we think of land. And one of the basic rights of property is the right to exclude. I can put a fence around my yard. I can put locks on my house to keep people out. I can decline to lend my neighbor my rake. But intellectual property is just ideas, and you can't physically stop people from using them. So we have enacted laws to protect our ideas and expression. And one object can encompass more than one intellectual property rights. So for example, the Mickey Mouse phone, we have the phone, which was at one point under a patent. We have this sculpture. If we think of this as just a sculpture of Mickey Mouse, that would be covered by copyright. And we recognize Mickey as Disney. He is acting as a trademark. So first, I'm going to cover patents. I'm going to briefly go over each one of these just so you know the difference. Mostly we think of patents as we protecting our inventions. We're protecting things that are useful or functional. There's also others called design patents that protect designs on useful things. And there is a category called plant patents. So if you are practicing botany and have created a new plant from, crossbreeding others, you can get what's called a plant patent, but most of the ones we think about are utility patents. And interestingly, it doesn't give you the right to actually practice your invention. For example, let's say I have patented the pencil and Emma has patented the eraser. And then Adrienne comes along and says, oh, what if I put a eraser on top of the pencil? And she gets a patent for that improvement. I can't practice the pencil, the eraser top pencil, and none of us can, because we need permission from each other to practice the different patents, to practice those different inventions. So the next category, let's say I don't want to have a patent, or it's something that can't be patented. I can keep it a secret. If it is something that has economic value and I take reasonable measures to keep it a secret, I can have my trade secret. It doesn't stop people from taking it apart and figuring out how it works, what's called reverse engineering. It only gives me a cause of action for what's called misappropriation. If somebody steals that invention, I have taken reasonable measures to keep it secret. It has value because it's a secret, and they have stolen that secret, either literally stealing it, or perhaps they have violated a confidentiality agreement or a non-disclosure agreement. So next one is trademarks, because I'm going through each of these. So trademarks protect brands. If you think of patents protecting inventions, trademarks protect brands. And I have rights here as soon as I use my mark. Patents, I got to wait for the government to tell me. Trademark, I can use immediately. I can enforce it immediately. I don't even have to register it first. And it gives me protection. I can stop people from using marks that are confusingly similar to mine. They're using another mark in commerce. I'm using mine in commerce, and there is a likelihood of confusion. But as we can see here with the example EOS, each one of these is called an EOS. But there is no confusion. There's no likelihood of confusion. I don't go into Walgreens, into a drugstore to buy a car. Okay, so we can only protect from confusingly similar use. So now this is what we all wanted to talk about. Okay, copyright. And this is where we're protecting creative expression. Okay, I have the right to the expression, but not the idea itself. Okay, we have to differentiate between an idea and the expression of that idea. So things like literary works or poems or dramatic works, choreographic works, musical works, all these things, sculptures, pictures, anything that is a creative expression can have copyright. Things that can't be copyrighted, methods of operation. You can't copyright recipes in a cookbook. You can't copyright things that are functional. Okay, so for that leg lamp that I had the picture of, I'm not sure how many of you are familiar with A Christmas Story from, it's an old movie that was very much recognizable. The sculptural parts are protected by copyright, but the actual light in the lamp or the phone on the Mickey Mouse, those would be protected by patent and not by copyright. Okay, and like I said, copyright is the intellectual property that's going to be most relevant to your books and articles. And the other thing you need to do is distinguish between the material object and the copyrighted work. So we have the books on in the lowest picture. We have the books, the copyrighted work, the literary work is embodied in that book. And once I buy that book, I can do things with it where I don't need permission of the copyright owner. I can sell it. Most of us probably have bought resold books, bought used books. They don't need the permission of the copyright owner to do that, but I still can't make copies of the book. That is still owned by the copyright owner. So in the US, how do I protect these? Oops, wrong picture. Well, in the US, as soon as I what's called fix it in a tangible medium of expression, I have copyright. So as soon as you're typing it on your computer, or you take that picture, or you draw it on that paper, or make that sculpture, or videotape those dance moves, I have fixed my creative expression and I have copyright protection. And it gives me the exclusive right to make copies and adaptations of the work and to distribute that work. I have the exclusive right to publicly perform and publicly display that work. Sound recordings are a little different in the US. There are fewer rights that aren't quite relevant for today's talk. And it's going to last in the United States. The copyright owner, if it is a known human, it expires 70 years after the death of the author. If there's more than one human author, it's 70 years after the death of the last surviving author. But if it's something like a movie where you ever see one of the Marvel movies and there is like a list of 3,000 people and they probably all have contributed copyrightable expression, there are two ways that they're not all copyright owners. One is it's called a work made for hire. And second, how do we figure out when the last one dies to figure out that length of time? And so instead, Congress has said for works like that, it's going to endure for 95 years from the date it was first published, or 120 years from the date of creation, whichever comes first. Okay, I get to decide who gets to make the copy. I get to decide who gets to make a derivative work or distribute it or publicly perform it. And I can license these rights. I can sell these rights. Okay, so oftentimes what's happening is the publisher wants to own those copyrights, and that's going to be part of the license. They don't want to just have a license. License is permission. Assignment means you are giving them the right. You are transferring the copyright right to the publisher. Okay. You no longer own your copyright if it's an assignment. Okay. And if maybe you don't want to give all copyright ownership to the publisher, well, that's part of the negotiation. Authors often want to retain control over their work and republish it elsewhere in another form, or have more leeway in terms of creating new editions of the book to make derivative works and exercise other rights. So you may want to be concerned. So what if the publisher, you give them all your rights and then they stop publishing the book? Nobody wants to buy it anymore. Books don't last that long anymore. And copyright correlates very significantly with the disappearance of works rather than with their availability. So this was created by Paul Heald in 2013, and it's changed very little. So we see it's easier to find a book from 1910 than it is from 1990, because these are all what's in the public domain. They're no longer under copyright. Everybody owns them. Anybody can make copies. You can find them on the Gutenberg Project. You can find them online. Anybody can print them. But then we have from around 1926 all the way to, we have copyright. These are under copyright. They're no longer profitable, so they're not publishing them anymore. And it's more difficult to find them. And we see the uptick when you have more common books in 2000 and in the 2010s will show that again. And what's happening is the author doesn't own the copyright. The publisher owns the copyright. Maybe the publisher's gone out of business. You don't even know who owns the copyright anymore. And you can't get your book published because you don't own the right to make copies anymore. Nowadays, see, the other issue here is that when all of these folks were making their contracts, they often said that they own them in book form. And so there's litigation going on now. Everybody is saying, well, wait a minute, I didn't say that didn't involve Kindle. Why can't I publish it in Kindle? The problem there is that it's what I call cheap permission or expensive forgiveness. Okay. I may say, well, I'll just do it anyway, and I'll ask for forgiveness later. Well, forgiveness really means a very expensive lawsuit that you win, and the court says you're forgiven. And so a lot of authors aren't willing to take that risk by publishing online because they're concerned about the expense of a lawsuit, that even if they win, it's a very expensive forgiveness. And we have this problem. Nowadays, it's going to be less of a problem because almost every book now is also automatically published electronically, and we have print on demand. So hopefully we will see this trend end in terms of books that are published starting around 2000 and going forward. So what can I do to prevent this lack of ability from happening to my publications? Okay. Well, one is that if the publisher, you can have it in your contract, yes, they want all the copyright, but you can negotiate and say, if it's not published or if it's only available online or the publications drop, the sales drop below a certain amount, I get the copyright back. Okay, so some of these ways we can do that is through open access, right reversion, termination, publication contract language. And I'll go through each of these. Okay, we're talking about specific contract language that retains these rights or have advantageous, what are called reversionary contract language. But even without that, sometimes publishers will just give the rights back to the author, especially if it's out of print, merely by asking them. So I'm going to go through each of these. So first we have to figure out, what do we mean by open access? That's a way of making copyright works available without all the access barriers. When you see all rights reserved model, they can take the form of price or permission barriers, and there are several forms. One is just making it available free online free of charge. We have what's called Libre open access, which means it's free on charge with additional reuse rights, so meaning people can recopy it and republish it. And some research funders and institutions require that works be made openly accessible. And there are a lot of benefits to this. It helps you reach readers who, by increasing the discoverability of your work, it helps readers access and use the information, and it benefits the dissemination and ongoing progress of knowledge. And we make our works accessible. A common way is using what's called the Creative Commons license. And usually if we want to grant rights that require republication, we want what's called the right of attribution. Okay, we want to make sure no matter when you publish it, my name as author is attached to it. Okay, you decide what publication venue you'll use. You can work with an open access publisher. You can do self-archiving. There's many ways around this. And actually, the organization that I worked with in creating this program, Authors Alliance, they have a guide on understanding open access. And it's available, I believe it's available free online on their website, and a small fee if you want to purchase the actual physical copy. So that's one way. And if you notice, probably you didn't notice, the very first slide, I had a Creative Commons license at the very bottom saying anybody can share this as long as their attribution, but they can't make changes. Another way is rights reversion. Okay, and let's say I want to make my book available and the publisher isn't doing it. Maybe it's out of print. Maybe I want to bring it back in print or release it as an ebook or make it openly accessible. But I've granted my publisher all the rights to do these things. And either permission, if there's no permission for me to do it in the contract, or there's no reversion, I can't. But there's two ways around that. Okay, one is the right of reversion. I have a contract clause that says I can regain rights if certain provisions are met in the contract, meaning the publisher isn't publishing it anymore. They can be called reversion of rights or out of print or discontinuance or go by another name. And this empowers the author to regain some of the rights. Okay, it can say, you want to make sure though definitions are, this is where you need a lawyer. Okay, it may say in print. Well, does that include an ebook or print on demand? You aim at lower numbers that so many people have to actually purchase it. Maybe there has to be X number of dollars of revenue generated. And the more author-friendly reversion clauses are going to depend on your situation and what you can negotiate. But even if my contract doesn't have a reversionary clause or those conditions haven't been met, it is still possible for me to take it back. Okay, the rights reversion. And there's actually another guidance by the Authors Alliance that also helps with that, understanding rights reversion. So let's say though, your contract says, I assign all rights forever under US copyright law. US copyright law forever isn't forever. Forever isn't even until the copyright has expired. Forever is 35 years. It's going to be nowadays it's 35 years. Under the older law, if you had something that was published prior to 1978, which is probably way sooner than any of you were probably even writing, that it was up to 56 years. There was a different window. But for stuff, if you assign it today, 35 years from now, you can take it back. Okay. Even doesn't matter if you signed an agreement in the it has a US contract that says you have rights forever. 35 years later, you have a window to take it back. You have a 5-year window where you can say, I am terminating your assignment. You no longer own the copyright. And I have to give them at least 10, at most 10 years notice and minimum 2 years notice. So anytime between 25 and 38 years after that agreement, I can say I am taking it back. They cannot do anything about that. It cannot be contracted away. It cannot be assigned to somebody else. That is it. I can take it back. I have this window, okay, and that is it. Oftentimes, it is to your benefit to hopefully have it in your contract. But the one thing you want to make sure you're not doing, and this only applies to certain kinds of works, is you're not saying it is a work made for hire. If you are working on an anthology, let's say we're often asked to write articles for specific volumes of books, that can be considered what's called a work made for hire, and there is no termination right. Okay, many of us we've seen these anthologies, these research manuals. We're asked to write chapters. We're asked to write chapters for encyclopedias of intellectual property. Those can be considered works made for hire if I agree to that. And I don't have the right to take back my rights if that is the case. So now I want to make sure it's very strongly worded that, well, I want to turn this into a law review article, maybe. I want to still be able to use that information. Those are important things to have in those contracts. Okay, so there's lots of tools to help you. Don't despair. Okay, both Authors Alliance and Creative Commons have created a lot of tools that help authors understand this timing and everything. And you can go in, and there's actually another feature that's run out of Tulane that you can put in your book and the year and everything, and it'll tell you when the rights are terminated. Okay, but let's say you're writing in that law review article. Okay, that's where many of us get published. We get published in, one day maybe I'll be lucky enough to be published in the Yale Law Review, but all journals have law reviews. So the journal is going to want as much rights as possible, but they really don't need them. Okay. In the past, law journals really wanted assignment. They wanted to own the copyright. Okay. And or they wanted an exclusive license. Nowadays, they're willing to take what's called a non-exclusive license. An exclusive license says, you and only you get to publish it. Nobody else I'll give it to. Okay. Non-exclusive says, okay, we have a non-exclusive license, but you can't publish it anywhere else for 6 months or a year, which seems reasonable. Okay. So this was an article that I wrote. This was published in the Berkeley Tech Law Journal, and you can see that they have a non-exclusive right to publish. They have royalty-free license, and they can do all these things with it. Okay, and I don't have a problem with them doing that because I still retained all my rights to do those things as well. They often, what they want is the right of first publication. They don't want to go through all this work of editing your article and getting it set up, and there's a lot of work that law review students do, then to have somebody else publish it first. So they want to make sure, that's usually the biggest thing they want, is to make sure they get to publish it first in their journal. They're the ones who put it on the databases. The copyright, though, always remains mine. I can send copies to other people. They may say that, well, if you publish it elsewhere, we want a statement that says it was published with us first. Very reasonable things. Most law journals are going to be very reasonable and are not going to ask to own the copyright anymore. Okay, but what about publishing content? What about books? Okay, it's important to read the contract. Many authors don't. Okay, You want to maximize your audience. Here it's saying, I can do these things. I can produce it in classroom use. Okay. I have to say where it was originally published. Okay. I want to negotiate my rights. I want to keep as much rights as possible in my work. I can ask for a clause that says, in 5 years, I can make a derivative work. I can revise it. Okay. I can copy a certain percentage of the works. The publisher may insist on a right of first refusal to a publishing to future editions, and that's fine. You say, hey, I want to publish it again. I want to revise it. And they may say, no, we're not interested. Good. You move forward and you can do it yourself. Okay. These are all terms that are possible to negotiate with the publishing house. Okay. So that's what I have for today. Like I said, there's Authors Alliance is really about helping authors have as broad a audience for their works as possible. We publish to be read. Okay, we publish to be read. This is different than like J.K. Rowling and Stephen King and everybody else who publishes fiction and things, and they're publishing to make money, to make, that is their source of income. We publish law review articles. I don't think I've ever made any money off of any of my law review articles. I'm worried about, I want them to be read. And that's, so you want your works to be read. You want to make sure you retain enough rights so that your works can be read. And that's it.
Thank you very much for that, Yvette. Very interesting, particularly with the reversion of rights, because it does operate differently in the UK. So I always appreciate getting the US perspective, especially as I'm interested in publishing in the US. I know some other people who have signed on today are also interested. So I think it's good for us to be aware of the differences.
Yes. There was an interesting case where even though there were reversionary rights in the US, because it was a British contract, they did not recognize the reversion and they called it a breach of contract. So where you sign your license is important. Where the laws governing your license is very important. The UK does not recognize the rights reversion. And so you can get into trouble if you try a rights reversion in the US where it's allowed, but the contract is governed by UK law.
So very interesting, also very important that that distinction is made. And interestingly, here in Trinidad, we often get importations of US law, not actually in law, but by people thinking that the US law is operating here, when in fact it's the UK law that we tend to operate under. So I think it's good to draw that distinction. I will open the floor for questions. I think we can take probably one question. Oh, Adrienne, you have a question. Okay, sure.
Is that all right? If anyone else has, I defer to them. Just a very quick question, Yvette. Thank you so much. Really interesting to hear about the US, given I'm based in the UK. Is the Authors Alliance an international organization or is it a US-based organization? I just was interested in that.
As far as I know, right now it's US-based and they're focusing on US law, but I know that they may have, since the last time I checked, expanded to incorporate Berne Convention, their Berne Convention countries, which would be pretty much every country. We joined like 100 years after everybody else, because up until then, like everyone else joined in like the 1880s, and we joined finally in the 1980s because we realized that, we suddenly had stuff that we didn't want people stealing. Because before that, we just liked to steal work because we weren't very creative. So we joined, and so now they are working on issues involving Berne Convention countries, which includes the UK, which was one of the earliest signatories, unlike us, who are like one of the last.
Thank you so much.
So while you were telling us about the reversion rights, Yvette, I looked up just some interesting reading that I think people might find helpful. So I found a link here. I'll put it in the chat. So this talks about the difference between the US and the UK. So I think it's really interesting for anyone who wants to know the different approaches, especially because sometimes we think one approach is the global approach, but as copyright is territorial, we need to know that there's different approaches. So very interesting to hear about the US approach. I think we can take one more question. Does anyone else have a question that they'd like to ask?
Thank you, Avanel, for the very nice compliment.
Oh, Justin, yeah, go ahead.
Thanks for that, Yvette. Really interesting. Always like to hear about the discussion about reversionary rights because I think it's so controversial just because of the fact that in the UK they got rid of it, I think after the 56 Act. So when 88 Act came around, it was out of the window, and it's being discussed now in the EU that they should bring it back. But my question is different. In terms of negotiation and authors having leverage over publishers, there isn't much leverage in the UK or the EU for negotiating. And I say this on like my own experience. So I published with Hart Publishing. I got 5% on my book. I'm not complaining because ultimately it is about getting it out there and getting it read. And, you know, the Court of Justice of the European Union cited it and all of that. So I'm
That's
grateful
really cool.
for that. Yeah, so I'm grateful for that. However, is there any sort of greater leverage in the US for authors to publish and get a better rate on their publishing contract in your experience?
I think in terms of the royalty rate, it's not going to, I don't think it's going to be much better. What they'll often do is have differential rates. So it may be one rate in the US and a different, like, let's say it's 5% royalties for sales in the US and 2% in another country. And so they'll vary it. They may vary the percentage based on the country. And that may have to do with things like basically price differentials in how much they're charging for the books. I think we're going to see a big shift in that too. Okay, there was a case about 5 years ago involving a gentleman by the name of Supap Kirstang, who realized that like chemistry books are really expensive in the US, and he was from Thailand and it was much cheaper there. So his family would buy them there and send them to him. And even with all of the charges and customs and everything, he was still able to sell them for less than the US books. And he was making a lot of money. And the Supreme Court said that's absolutely fine as long as the permission of the US copyright owner, it was printed on the permission of the US copyright owner anywhere in the world, that's fine. So he was doing arbitrage, whereas the publishing houses were trying to do price discrimination and charge different prices and not allowing books to come into our country that were published in other countries. So that I think has made a major shift overall, just in terms of the sale of books and the charges for them. I think there's going to be a difference. I mean, first of all, one of the things, even if it's a British publishing house, the choice of law is going to matter. So unfortunately, in the US, if you're talking about a multinational publishing house, they may decide the laws of the UK govern, in which case there are no reversionary rights. So they are trying to be sneaky around things like that. I think that one of the things about having leverage is getting multiple offers. I think what it really comes down to is you don't have leverage until you have more than one offer. And that's going to be true for about everything. That's probably the best.
That makes a lot of sense. Thanks for that.
Yeah.
I note though that sometimes some of these publishers don't want you to send the book to anybody else. That's probably a whole that's a different discussion that we could have.
Well, no, I mean, let's say I have an offer from Cambridge University Press and another offer from Oxford University Press. And I say to Cambridge, well, Oxford's offering me X. And they're like, well, we'll give you Y. And then I negotiate between them. And then whoever gives me the best deal and what I want the most is who I sign with. So that's what I mean. It's like, during the negotiation, if I have multiple offers, that's when I have the most leverage. And Justin's absolutely right. If it's one offer and it's the only one you got a whole lot less leverage. He's absolutely right there. But where you have leverage is when you can get multiple offers.
Okay, makes sense. Although I think we can all agree we're probably not going to get rich off academic publishing, but we don't do it for the riches because we're way up that.
Yeah. But the negotiation to me is the negotiation to own the rights and to make sure it keeps getting out there. And that's just, you may be willing, that's also negotiating. I'll take fewer royalties if I have more copyright right.
Yeah. And I think
that's also part of the negotiation.
A very key. And in fact, I think that brings us nicely to Adrienne's topic. So Adrienne's going to speak to us about research impact. So Yvette, thank you so much. So now that we've heard about copyright and the importance of understanding these rights and your relationship with your publisher, this brings us nicely on to research impact, which has been a hot topic recently with people talking about, well, what are academics actually doing? Do they do things that impact the real world, or is this still a kind of 1980s ivory tower world we are in? think we could all agree it's not the 1980s anymore, and thank God. But what is actually happening in terms of academics and their relationship with the real world? So Adrienne, I hand it over to you for research impact.
Thank you so much, Emma. Thanks really a lot for this invitation. It's a huge pleasure to be here and to speak to everybody all across the world. Thanks also to Yvette for starting off this research seminar so nicely. I actually think that my presentation will flow quite well from Yvette's. I'm talking about research impact, as you can see from my slides, and I am Dr. Adrienne Yong. I am a senior lecturer, which I think is the equivalent of associate professor in other jurisdictions, at the City Law School at City University of London, based in the UK. So I suppose the housekeeping things is that my presentation will mainly focus on the UK jurisdiction, as that's what I am based in and what I actually know best. In fact, I don't think I know very much else about any other jurisdictions, but I do understand, of course, that making research impact is something that lots of people across the world are interested in doing. And the reason why I would say that it flows so nicely from Yvette is because of this idea of making things accessible, I suppose, and making sure that everybody can get to our research. And also, obviously the first step is going to get behind the paywalls, but the second step, I would say, after that is, of course, making impact. Now, Emma started off the seminar series today by, using this idea of research as a impact rather, as a buzzword. And indeed, it has been a buzzword for some number of years. And over the years, I think people have started to learn a little bit more about it, especially here in the UK. And I will explain why that is. But I'm just going to present a very brief overview of what I have learned research impact is over the last couple of years, a little bit about my experience, and then you can all decide whether your research is something that you would like to have research impact, because we will learn that given that everybody's research is so different, and particularly legal research can take the form in many different forms, sometimes research impact isn't what you think it is. So let's debunk all of these myths and see exactly what we all mean by research impact. So we all know, as Yvette already spoke about very, very nicely, that we write papers, academics write papers, and they want to get it published. And then when it's out there in the world, hopefully, open access, which is the gold standard, as it is, it's described like that in the UK. We want many people to read it, but we also want them to kind of understand it. And then maybe for it, especially in law, to have more of an impact than just somebody published a long piece of work and then put it out there on the internet for everybody to read. So research impact refers to impact in particular that is beyond the academy and into the public sphere. So we can kind of see that it's not just us, at the higher level who maybe have expertise, who have an interest in this work that we're writing. It's going beyond that to making the impact, as the term suggests, in the public, with the public and with people who perhaps may not be experts or may not be academics. The aim of research impact is, of course, to encourage greater knowledge exchange. So that's making sure we speak about ideas, we exchange ideas. And of course, impact in particular can be achieved through public engagement, as in making sure that people out there are understanding and listening to our ideas and our arguments. So there's a definition from the Higher Education Funding Council of England in the UK, HEFCE, on the screen as well in the speech bubble. Impact is the demonstrable contribution of research to changes that bring benefits to the economy, society, culture, public policy or services, health, the environment, or quality of life beyond academia. And I think then, therefore, the debunking idea is that impact is beyond academia. It is not just how many people have cited your paper in your own field, and it is not how many times your paper necessarily was downloaded, but it's actually something a little bit more concrete. It's changing stuff, it's bringing benefits, and I would argue, at least when I started out and applied for law school in the UK, that I wanted to do law so that I could change the world. And I guess that a lot of law students still have that idea. And when I became an academic, I also maintained this idea of wanting to change the world. And so that's why here I am trying to make research impact with my own research. In order to make research impact, my view is that there's sometimes a bit of a confusion between research impact and public engagement. And I would say public engagement is something that can inform or create research impact. So this is easy for me first step in which to begin, because it is to describe research impact as very much moving beyond just pure dissemination. So beyond just like having many downloads, as I mentioned, and it really moves towards involving the public with the process of the research cycle. So it's not just me as an academic in my office where I am today, reading papers, reading books, and then writing stuff, and that's it. It is more about ensuring that actually embedded within my actual carrying out research and writing the paper that I end up wanting to write, it's more engaging with the public. So it's not so siloed. And this helps to inform research with evidence-based opinions on the ground. And sometimes we think that law is quite inaccessible, quite technical, or quite a high level, and it cannot really get to this. But I think that that's what our challenge is, really. So the National Coordinating Centre for Public Engagement in the UK as well defines public engagement as the myriad of ways in which the activity and benefits of higher education research can be shared with the public. So it's by definition, engagement is a two-way process involving the interaction, the listening, and with the goal of generating mutual benefit. And this is really important because I think sometimes there is this view that, academia, very much we all sit in our offices, we write stuff and no one reads it, and only a very small group of people care about it. And this is really how we go beyond that. And for me, I'm very passionate about this due to the nature of the work that I do. So I hear you ask exactly what types of impact are there? And this slide in particular can show you all the different ways that you can actually make research impact. I have to credit the Fast Track Impact website for this, Professor Mark Reed, a very famous professor who has written quite some number of handbooks actually on research impact. But here he very nicely visually outlines all the different ways that you can make impact. Now, I would like to highlight your attention on the one in the middle of the screen, which is policy. I think a lot of lawyers in particular doing legal work focus a lot on this area, changing policy, making sure that our research goes to the very top, to the government, so that they can say, yes, we're going to change the laws and we're going to make, in my interest, immigration law kinder to refugees, something like that. And that is, of course, a type of impact. But as you can see, Professor Mark Reed has set out that there are many different ways you can make impact. You can also make impact by changing somebody's understanding or their awareness of an area. You can change their capacity or rather contribute to the capacity or their preparedness to do something. Other decision-making and behavior change impacts, but also there's lots of different things that you can influence, such as one's attitudes towards something, one's health and well-being, cultural shift might be part of it. Of course, there's social kind of aspects and, very important to us today, economic impacts and environmental impacts. So it's a plethora of things. And I do think that sometimes legal research, as it lends itself so well to policy, lots of legal academics focus so much on trying to change policy, which is, of course, really, really difficult when we can kind of go a bit lower down the ladder, if we're going to use that term, and actually seek to influence instead somebody's attitudes or their awareness or their understanding of an area. So we're just going to break down all of these different areas just for the sake of anybody in the room who's maybe not a legal academic, but looking at how their non-legal research can also make impact. So as I mentioned, understanding and awareness and attitudes, these are things about people understanding an issue better than they did before. So that's educational. Arguably, that's a very straightforward way to make impact and something we would all kind of want to do. Changing an attitude, this is really important, of course. Researchers want to change the way people see things. And of course, the idea is to bring benefits. And then there's more concrete stuff, the economy, the environment, health and well-being, monetary benefits, the environment in terms of conservation and sustainability, which is, of course, a very hot topic nowadays. And the health and well-being of people, better outcomes for the health of individuals. That's been very hot because of the pandemic that we have all gone through. And then, of course, policy, I won't go too much into that because we've talked about that. And if you're a legal academic or a law student, you might know about that. But of course, then there's, again, this is a little bit more the less concrete stuff. So changing one's, decisions or the way they make decisions or a behavioral change. This kind of feeds as well into culture, which is, changing kind of patterns of behavior, as it says. And then, of course, influencing capacity and the preparedness of individuals to do things in the future, as it says, to future benefits or ability to cope with changes. And of course, our world is very much all of this at the moment, and therefore there is a very good reason why we should be interested in making impact and all the different types of impact that exist. So the real question for you all to be asking yourselves, I suppose, or me asking you all, is why should your research make impact? Now, I've thought a lot about this, and I think that there are maybe two camps that what you might fall into. And I'm going to say again that this is from the perspective of somebody based in the UK and has done all her higher education in the UK and has her career here. But in the UK, there are institutional reasons, I describe them as, for why your research should make impact. And that is the fact that if you want a funding grant, a large bid amount of money to do your research, funders in the UK, some of them specifically require you to outline as part of your proposal how you are going to create a pathway to impact, how your research is going to make impact, how your bid, your project is going to do so. In the UK, we have this exercise as well. It's known as the Research Excellence Framework. It comes about every so often, where universities submit their research and they rank it or score it in a way, and this then determines how much money the government will give universities to do research. And in the Research Excellence Framework, the REF, there is a whole section on impact case studies. So it also requires it. And for the reasons of the fact that impact is actually so important, the issues that Yvette was talking about in the copyright has become actually less of an issue in the UK, because most of the time, actually, in fact, when you have to submit something for REF, it needs to be open access. So most institutions in the UK nowadays actually support open access and have paid a certain subscription in certain different journals or different hosts of journals to make it open access for these reasons. So that is one reason why some people think they need to make impact, because it's kind of required. However, I would argue that there should be wider professional reasons, and this is certainly what drives me for making impact. As mentioned earlier on, the research cycle should include the public. In my research, which I'm an EU lawyer, I focus on EU citizenship and I look at immigration from a feminist and intersectional perspective. This is really important for giving voice to people that I research about. So it needs to include the public. In order to get outside our siloed ivory tower that we are always criticized for as academics, research should make impact, and then you can see how it actually works on the ground, and that's lovely. And of course, if you want your research to make impact, this can mean that it underpins your papers, your research, your work, actually underpins change, and then therefore there is a really good reason to support change by making the arguments that you do in your own work. And that's really what drives me. So then, how do you make impact? We talk about making impact. Everybody's now convinced that beyond just the institution that okay, I want my research to make impact. Okay, exactly how do you do it? It is not as easy as it might appear for many, many reasons. I mentioned a couple of them in terms of policy change and how that's quite high level. But basically, how you make impact? Well, the funders, or the technical term, I guess, is to call it a pathway to impact. How do you create a pathway to impact where your research then follows this lovely path, this nice path as you see on the screen, towards the end goal, which is making impact, being part of society, changing attitudes, etc. In law, often impact often seeks directly to link to practice or policy, and really going towards that, and that's a very clear way of impact, making impact. And of course, it's the ultimate ideal goal. That's what I sought to do in my career. That's what I wanted to do when I was applying for school, for university. So the ultimate ideal goal is, of course, changing the law or the policy in itself. But it is possible that you make impact on a less high level, I like to describe it as. And I think this is where we would like to probably start and then kind of more to encourage more people to do so. Because grassroots impact, I would argue, is in a way easier as well. And it's a good starting point with the people that your research kind of speaks to. So in my area, I do a lot of work on immigrant women. And so I'm currently working with a third sector non-governmental organization who works with vulnerable women and provides legal advice to them. So my research about the obstacles they face in the immigration system. If I work with this NGO, my idea of impact is to hopefully inform their work on legal advice, to then inform and then help the ultimate stakeholders, which are the immigrant women going through the processes of immigration process in the UK, which is not easy. So of course, you can go for those a bit less high level. It's not necessarily going to change the law tomorrow, but you can inform or you can educate the relevant people on important issues. And hopefully by starting there and then creating the network and creating smaller, lower level forms of impact, you can create more ripple effects that may occur. And that is the start of your pathway more directly to making real impact. So if you are interested indeed in making research impact, you might ask yourself, okay, where can I actually start with this? It's not just so easy that tomorrow I go and work with a random non-governmental organization. I would say that there's kind of two things that you can do at this very early stages if you're not already very involved in impactful work. So the first thing I would say you would need to do is actually think about your research and really truly ask yourself, is your research intended to make impact? Not everybody's research is intended to make impact for various different reasons, depending on the type of research it is, depending on what you're looking at. But you really need to think, is it impactful in the way that I've kind of talked about? How is it impactful? Why do you think it's impactful? Where, location-wise, can it make an impact? With who? Really think about that. And then once you decide, okay, actually, this is something that I can, make an impact with, you need to have a clear idea what kind of impact you want to make in mind. So be realistic. Are you going to change the law tomorrow? Or is it better for you to maybe start with changing attitudes or behaviors of the target group that your research speaks to? I believe that in order to start making impact and to get, to do the public engagement element, which I think is a very good first step, you need to start making your moves. You do need to be well known, or be known at least, perhaps not well known, but be known for what you do and what you want to do. So I believe that it is useful to ensure you have a pretty good, in this sense, an online profile. Obviously your offline profile is important as well, but being visible out there is important. LinkedIn, Twitter, there is a very, very good website which publishes like journalistic articles of academic works called The Conversation. And then I put Mastodon on there because as a question mark, I mean, I haven't moved to Mastodon off of Twitter yet, but perhaps that is where we're going. But you know what I mean in terms of the social kind of media, but the professional social media. You need to have a good online profile in the right places so people know you for the right things. I also would say that you probably need to then start, and luckily, our day and age is perhaps allowing this a little bit more now, but it starts to attend events, start to network with relevant people and relevant organizations and make those links so that you can then say, okay, I am doing this research. Would you be interested, or is it of interest to you, for example? And doing events, or being invited to events, or going to an event where people speak is all fantastic for this. The reason why I have this link with the non-governmental organization that I work with, they're called Rights of Women in the UK, is because we were both asked to speak at an event in Parliament a couple of years ago, and so I met them there. Things like that. You never know who you might meet at these events, and I do think that's important. But then, of course, not just running your mouth off at all of these places, but writing, because ultimately it is your writing, your research that needs to make the impact. So instead of just writing inaccessible, as we were speaking about, papers that only experts can read, write for academic blogs in shorter form, write for perhaps news outlets. I would highly recommend The Conversation. You can put a pitch through there and then they can see whether there is an interest in it. I really think that that's where you can make a start. And this is where you can then start to build the pathways to impact that you need to ultimately, do your ultimate goal in law, let's say, of policy change. Or maybe that's not your ultimate goal. Maybe you just want to help the vulnerable person on the street from not being so vulnerable anymore. So if you are interested in more on impact, then I would recommend you have a look at Mark Reed's Research Impact Handbook, which I have here, which I received actually from my research office for me to read. And very happy for you to connect with me as well. I'm on all of those socials that I mentioned, not Mastodon, as I said before. But yes, I am very happy to take any questions now. And just to say thank you again to Emma for inviting me to do this.
Thank you very much for that, Adrienne. It was very helpful. As you know, I wasn't mentioned to you before. I was trying to figure out what exactly is research impact entail. We have had discussions on our campus, and to be honest, a lot of the discussions have focused on the metrics. And while I love when I get cited, I'm very excited to get published in nice journals and all that. I think that's great. I think the way in which you broke down impact was very helpful, particularly going from the grassroots up, because yes, I'm sure we all want to change some type of law. That's our ultimate goal, right? But realistically, as you indicated, that's a long-term difficult thing to achieve. So I do think that the different types of impact are important to recognize. And I think it's very helpful how you broke it down, because it actually has started driving me insane, the level of focus we put on the impact factor attached to certain journals, and not recognizing that realistically, if we want the public to be impacted, we need to think beyond that. So of course, we all love getting cited, but I love how you broke it down.
I think the impact factor in journals is not actually the impact that I was talking about anyway. The impact factor is more how many people are going to read this paper, because it's Nature or whatever it might be. But realistically, how many of us, I mean, no lawyers will publish Nature, I imagine, but yeah, absolutely.
Yeah, and I totally agree, because again, I like that when I get cited, very fun. And it's important obviously in the academic community, but I think moving beyond the academic community, as you indicated, we need to actually be on the ground talking to people, whether it's changing attitudes, changing understanding. So for example, yesterday, Justin and I gave a lecture on copyright and film. And I was speaking to one of the attendees yesterday, and he was saying this was very enlightening for him, because now he better understands his rights. But also he said the attitude needs to change locally, because we have developed copyright laws in Trinidad, but corporate sector does not respect them. So they will take advantage of individuals in the creative fields. And then if the individual tries to enforce their rights, they will blacklist them. That is what the person told me. If I try to enforce my rights, I get blacklisted. I don't get jobs. So I think educating people to their rights is important as well, because if you have one person standing up, they'll move on to the next person. But if you have other people standing up and all saying, no, we know how we're meant to be treated, we know that there's existing law in place, then that actually can force the hand of corporate entities to say, well, we better respect these rights.
Definitely. And that's certainly a form of impact, right? Without necessarily changing the law or anything like that.
Yeah. So I think sometimes the law might be there and it might be okay. Other times, obviously, it's horrendous and needs to change. But if the law is actually there, sometimes it's just to get people to know about it. Does anyone have any questions for Adrienne?
Thanks for a terrific presentation.
Thank you, Yvette. I thought it's flowed very nicely.
Yeah, I think they went very nicely hand in hand. Okay, so I actually have one question while people are thinking. Yeah, so I'm seeing some thanks coming in the chat. So I think, can all agree on the different types of research impact. However, when you have to explain this in a promotion application to your university, how would you recommend people go about evidencing impact? Because I can say, I have done these public lectures, these people attend, I got these comments, but that is a bit harder to prove than what they tend to have the concrete evidence for, which is the journal impact factors. So in your professional viewpoint, how can you tell your university, listen, I have done these things, I think I have achieved impact here?
Really good question, Emma. Yes, I think that anybody in the academy will kind of be struggling or thinking about this question. Certainly, it's one that I've asked myself as well. I think that My view of it is probably a little bit clouded, I have to say, due to the fact that we have in the UK the REF that I mentioned, where there's very strict and specific criteria for how you show impact. So I think, and maybe someone can do research on this and then make impact, because I think it's a cultural change, actually, that needs to be more widespread throughout universities, where it is not just indeed somebody going to Parliament and speaking to Parliament and changing the law. I guess it's then it's like a task in educating our institutions that it has to be beyond dissemination and just like 100 people coming to a lecture, let's say. It needs to probably go a little bit beyond that, and then you could speak to somebody and ask them, what's your experience of what I kind of told you? Has it changed your mind? And in ref, you have to kind of get a paper and where someone's like written a letter to say like, yes, this person's changed my mind. But I think that that's probably the way that you yourself can feel that it's impactful, and then it's about educating your managers or whatever it might be, that is actually impact. It's smaller impact and it's not like law changing impact, but it's impact nonetheless. And it's going to be it's a tough question, because I think we all struggle with it, and the shift change is difficult and not really there.
Yeah. Well, I think we've gone from.
Can I give some suggestions? I'm sorry.
Yeah, go ahead.
So, I mean, having been someone who's had to go through this twice, the first promotion to tenure and then to full professor, I think, especially women, we're so often told not to promote ourselves that we forget that there are ways to do it in our CV and in our writings. Even things like using the word, I was invited to speak to this organization, talk about the organization's impact. And that way you don't actually have to find the actual metrics for your particular impact. If you show this incredibly impactful organization invited me to give a talk. And it's really about promoting yourself, and you're looking for data that oftentimes is specific about you, which isn't necessary. And if they're and you'll find that if you just look for ways to show the impact of the organization with which you speak, then you can infer this incredibly impactful organization asked me to talk to them. And that in itself, and talking about how they are impactful, that they've been around for this, and the greatest scientists in the world, or lawyers, or whatever, are part of it. And they often, rely on this organization and the speakers for X, Y, and Z. What's somebody going to say? Oh, well, how do you know it wasn't yours, that you weren't the dud? No one's going to be like, how do we know you weren't the dud? Okay. We think that in our brain, because we oftentimes, discount our own reputation, but I think it's a matter of learning how to express that impact in ways that are a little less with a metric about ourselves.
Yeah, I think that's really helpful, Yvette. And I think you're right. As a woman, we are often sometimes put down and told the self-promotion is not what we should be doing, but in fact that is actually what we need to be doing. Adrienne, I see there's a question from Jolie in the chat. So Jolie, by the way, is our amazing law librarian. She's probably listening to me to say all these things about the metrics and whatnot and how I don't like them because she has to be involved in that process actually. So she says, what are your thoughts on alternative metrics, example, alt metrics, keeping track of discussions in the public space like blogs and tweets, etc.?
I mean, absolutely. A really, really good way to show that you are kind of making, engaging with the public or making that kind of impact, definitely. It's lovely always to see you go on alt metrics, you see like the number ticking up and up and up, and it's great to see how many like downloads and reads and everything. I suppose the thing is, what I was trying to get across is that there is a bit of a misconception that impact is just like citations or number of downloads or all the alt metrics, really, because I think that, Emma, as you say, like it's amazing to be cited and it's so great, but too many people cite themselves nowadays, right? So citations are not really the greatest indicator of how far-reaching your paper necessarily is, and at least, and I have to say that my view is now very much clouded by the requirements of the REF in the UK for really clear, concrete impact, which is not just how many people read your paper. let's say. It is, did you change somebody's mind and how can you show that? So whilst I certainly think it's amazing to keep track of it through altmetrics, etc. I guess it's kind of your sentiment on it, Emma, like that this number doesn't mean necessarily anything, right? And there's of course the gendered element, which Yvette was mentioning. I absolutely agree with that. You know, if you're in an area which is quite niche, fewer people are going to be interested in, maybe fewer people writing about it, so then therefore fewer citations. So you can't, I don't think necessarily that that's the best indicator of the impactfulness of your research. And I would personally say I would rather have, immigrant women, like I say, vulnerable immigrant women, tell me, or somebody's life change, one person's life change, than having 1,000 reads of my paper that I wrote. So I guess that's my view on it.
Yeah, and I totally agree with this view, as I have expressed to my university. So that brings us to a lovely close to our last RSS for the semester. Thank you so much both to Yvette and Adrienne for speaking with us today. We will continue the series next semester, so do keep an eye on LinkedIn, and for those of you who are on the mailing list, you will get the information. But thank you both for being with us today, especially as I know it's crunch time for us all. We're coming down to this exam period, so thank you for giving your time and your expertise today.
Thank you so much for inviting us and running a terrific program. And I really appreciated the opportunity to give my presentation to, the people who are here now and the folks who will be listening to it later on the recording.
As did I. Thank you so much, Emma, and lovely to meet you, Yvette, and everybody else. Thanks for coming.
You too.
All right, so thank you, everyone, and I hope you enjoy the rest of your day.